So a federal judge in Texas just used the Supreme Court's New York State Rifle and Pistol Association v. Bruen decision to find that the federal law which prohibits individuals who are under a felony indictment from being able to purchase firearms is in fact unconstitutional. So let's talk about this. But real quick before we jump into this video, if you agree that more judges should use the Bruen decision to strike down these federal gun control laws, go ahead and hit that like button and subscribe. So like I said in the intro, a federal court in Texas just used the Supreme Court's New York State Rifle and Pistol Association v. Bruen decision to strike down a federal law as unconstitutional, and as a result, a critical part of the 4473 has also been deemed unconstitutional. The case we'll be talking about in this video is USA v. Jose Gomez Quiroz. I'm going to just call him Mr. Gomez. This decision comes out of the Western District of Texas and was ruled on by Judge David Counts. In this decision, the judge found that Section 922, subsection N, which prevents individuals under felony indictment from receiving any firearms, is in fact a violation of the Second Amendment. In reaching that decision, he used the Bruen text as informed by relevant history and tradition standard, and this is one of the first times that we see a federal court, a federal judge, striking down existing federal gun control laws using that Bruen standard. So the facts surrounding this case are actually really interesting. On June 9th of 2020, Mr. Gomez was indicted in a Texas state court for burglary, which is a second-degree felony. He subsequently failed to appear for his hearing on that burglary charge and was indicted almost a year later for jumping bail and failing to appear, which was a third-degree felony. In late 2021, while both of the charges were pending, Mr. Gomez attempted to buy a .22 caliber 1911 from his local gun store. During that purchase on the 4473, he denied that he was under any indictment for any felony charges. The NICS check on that 4473 and the purchase of that firearm was delayed, the response was delayed, and therefore he waited 7 days and then actually went and picked up his firearms because, as many of you are aware, if the FBI fails to respond to your background check to that 4473, to that process within the appropriate amount of time, within that required amount of time, then the dealer can release that firearm to you, and that's what happened in this situation. However, less than a week later, the ATF was notified that Mr. Gomez illegally purchased a firearm. He was then federally charged in March of 2022 of 2 criminal counts, the first being making a false statement during the purchase of a firearm, and the second, the illegal receipt of a firearm by a person under indictment. He was ultimately convicted of both of those counts. However, just 1 week later after his conviction, Mr. Gomez moved to set aside that verdict and that determination and sought for the court here to reconsider the previous motion to dismiss that he filed because of the Supreme Court's recent ruling in Bruen. His motion hinged on the unconstitutionality of Section 922 subsection N, because if the provision is deemed unconstitutional under Bruen, then this false statement that he made during the 4473 process, the illegal possession and receipt of that firearm is completely immaterial. So this is what led to the federal judge here reviewing whether or not Section 922 subsection N is constitutional under the recent Bruen decision. And ultimately, the judge here found that Section 922 subsection N on its face is in fact unconstitutional, and therefore that section as applied to Mr. Gomez is also unconstitutional. And again, this is a big deal. You have a federal court judge applying the Bruen standard to find that this federal law does in fact violate the Second Amendment. Now let's take a look at the decision and some of the language that this judge included in his order. In his decision, the judge first starts by rejecting the government's argument that Section 922 subsection N does not implicate the Second Amendment's text, since the government here argues that it only impacts a person's ability to buy a gun while they are under felony indictment. However, the judge found that this conduct is in fact protected under the Second Amendment and the text of the Second Amendment, since the conduct in question is a person's ability to receive a firearm. He concluded that this conduct is clearly protected under the text of the Second Amendment, and therefore under Bruen, the government bears the burden of justifying their restriction, the 922 subsection N. They have to justify that with relevant history and tradition dating back to 1791. That is the clear standard that was outlined by Justice Thomas in the Bruen decision, and that is what the judge is applying here in this case. He then looked at the historical arguments made by the government to justify 922 subsection N. In this section, he states, the government analogizes regulations prohibiting felons from possessing firearms with those prohibiting receipt of a firearm by a person under indictment. However, the judge here states, yet the government fails to explain why regulations enacted less than a century years ago count as long-standing. With nothing further, the government's argument can be boiled down to the following. 1. Felony in possession laws have the same history as Section 922 subsection N. 2. Heller endorsed felony in possession laws as constitutional. And 3. Therefore, Section 922N is constitutional. And then he goes on to completely obliterate this argument made by the government. He states, the first problem with this argument is it is a logical fallacy. Sharing a history with felon in possession laws makes Section 922N constitutional in the same way a dog is a cat because both have 4 legs. He then goes on to say that the second problem is that Heller's endorsement of felony in possession laws was dicta. Anything that is not the court's determination of a matter of law pivotal to his decision is in fact dicta. The last and most significant problem with the government's argument, he states, is that there is a lack of historical analysis from the Second Amendment's ratification, much less anything pre-1938. So the judge outright rejects the government's only argument that they put forward to why this law is permissible. He goes so far as to call their argument a logical fallacy, which is definitely something you do not want to hear a judge say when you are putting forth arguments in a lawsuit. Also, he hits on the important point that the government is simply using dicta and Heller, and that is not a strong enough argument or a strong enough basis to support this federal law. And finally, he says that the government presented no historical evidence dating prior to 1938 to justify this law, and that's actually what they had to do under Bruen. Since the government did not present any historical evidence dating before 1938 to justify this indictment restriction, the court and the judge here went ahead and did his own analysis, and ultimately, after going through English law, early colonial law, some stuff after as well, looking at surety laws, a lot of basis that was also, and a lot of arguments that were also considered in the Bruen decision, he ultimately found that nothing in our nation's history justifies prohibiting someone under indictment from being able to receive a firearm. He also looked into the history of indictments and the whole grand jury process. He stated that the nature of grand jury proceedings is one such area that casts a shadow of constitutional doubt on Section 922 subsection N. Some feel that a grand jury could indict a burrito if asked to do so. And again, this is something you hear said all the time. Sometimes I hear it referred to, or I say it is, a grand jury would indict a ham sandwich, but here he's saying that they would indict a burrito. So in that section, he points out the glaring issues with indictments and the grand jury process, and how it's so problematic and that process is so problematic that it shouldn't be used as a basis to strip someone of their fundamental rights. Therefore, he concluded that the Second Amendment is not a second-class right. No longer can courts balance away a constitutional right. After Bruen, the government must prove that laws regulating conduct covered by the Second Amendment's plain text align with this nation's historical tradition. The government does not meet that burden. Although not exhaustive, the court's historical survey finds little evidence that Section 922N, which prohibits those under felony indictment from obtaining a firearm, aligns with this nation's historical tradition. As a result, the court holds that Section 922 subsection N is unconstitutional. It is therefore ordered that defendant's motion to reconsider is granted and that the indictment is dismissed. So that is a very big win. I cannot emphasize that enough. You have a federal judge who just used the Bruen text as informed by relevant history and tradition standard to strike down a federal gun control law. This also struck down directly an aspect of the federal 4473, that whole paper process, that one specific section has been deemed unconstitutional, and it's been deemed unconstitutional on its face. Now, there's another thing that happened with this. The government here is seeking an appeal up to the Fifth Circuit. They have already filed for that appeal. There is notice of that appeal. So likely what's going to happen with this order is it will be stayed. The decision of the court will be stayed until it can be heard on appeal by the Fifth Circuit. This is also a good thing because we want these circuit courts to look at these cases. We want them to have to grapple with these questions in a post-Bruen world. And again, this is going to be a very good case, a good vehicle to look at this type of issue. So now that this case is going to head to the Fifth Circuit, this is definitely a case we'll be wanting to keep our eyes on. If we get any more information, I will definitely let you all know. If you have any questions, go ahead and comment down below and I'll try to answer best of my ability. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is Built by Armed Scholars, and this nation will be maintained by Armed Scholars.